Balake, where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Aaron.
Aaron is present, everyone. Thanks for joining me for some more SPTV. And thank you, Zach, for joining me again. Are you there?
Yes, I got you now.
Guys,
there we go.
Guys, I have Zach's channel linked in the description down below. The name of Zach's channel is Your Lawyer Friend Zach. And he's doing some awesome stuff over on his channel as well. We have a few things to discuss, and I'm glad I can pick your brain because I think I've got questions about, 3 different actions here. I've got questions about the Danny Masterson stuff. I've got some questions about the grand jury investigation into Scientology obstruction of justice. And I got a question about Leah Remini's civil lawsuit. But let's start with Danny first. In my previous coverage of the last Danny Masterson hearing, where Danny's team told the judge they were requesting an extension. They needed more time before sentencing. They wanted sentencing to be postponed. I don't believe it was accurately described that the reason for this was not so that they could have more time to work on an appeal. The reason for the request for a delay was so that they could have more time to work on the request for a new trial. Mm-hmm. And I don't think I've properly discussed that before. I was a little surprised when I fully understood this, that the judge's response was, well, look, sentencing is scheduled for September 7th. I'll give you until September 5th to submit your full and proper request for a new trial. And because the Deputy DA, Reinhold Müller, will not have enough time to submit a written counter, whatever you want to call it, you know better than I.
Right, response.
He's going to verbally argue against their written request for a new trial. Now, I'm thinking to myself, if I'm on the defense team, I'm going to be sitting here going, well, I'm getting played here. Like I'm thinking, Judge, you're not taking this request seriously because we're asking for a whole new trial and you're not even going to see our request until 2 days before sentencing. I'm a little confused about this.
Sure.
Can you help me understand?
Sure. So a couple of things. First, a motion for a new trial is as routine as it gets. It's borderline malpractice to not file one. It doesn't matter how egregious the evidence was against the defendant. The reality is that a lawyer's not doing their job if they don't exhaust every avenue to get relief to get their client back on the street. Even if it were to get, let me start with, I don't think it's going to be granted. I don't know. I have no reason to believe that there was serious misconduct by an attorney or a juror or the judge or any court personnel or even the media and the press that would give rise to a new trial. But it's almost malpractice not to try. Mm-hmm. So I don't think it's going to be very successful. Secondly, even though the judges only get the chance to look at it for 2 days and the deputy DA is going to have to argue it sort of from the hip, the reality is the law in every state that I know of, including California, regarding what it takes to get a new trial is very settled. The case law is very clear what the elements are, what the thing the court has to consider is, what the parties have to prove, what burden do they have to prove it to. The law is very settled. So it's just basically arguing the facts that you believe and the circumstances that you believe exist in support of the motion for new trial. But the ability to satisfy the motion for new trial request is really, really high. So it's actually harder to get it. It's one of the hardest things to get approved. And the reality is as well, although there's generally a limited timeline to file these, you could have sentencing and post-sentence, Masterson be remanded to custody and then file a motion for new trial at some point in the future. And if it's granted, he's released from custody. And this, even if it gets granted, it doesn't let him walk free. You just go back and you try the case again. It doesn't reset the whole calendar. Basically, you go back and say, are you ready to pick a jury today? Sort of like after the mistrial, right? They mistried it in November and I think they started trial in like May or June, whatever it was. It was originally scheduled for March, and then there were some preliminary things, which is super, super common. But it's not going to be years like it was to get to this point. It's going to be months if it were to get retried. But I'd bet all the dollars in my pocket, the motion for a new trial is going to be denied. That is also another grounds, another basis for which Masterson will likely appeal this sentence. Is that even if all the errors he's claiming happened in trial aren't true and didn't happen, the judge should have granted the motion to dismiss for these reasons. So it'll be another grounds for appeal. I also don't think that appeal is going to be successful, but that's certainly why they're doing it.
So was it just pure theater for Sean Hawley and Cohen to show up almost 3 months after the verdict and say, we just need more time to work on this request for a new trial?
Probably not. Given the length of that trial, it probably took several weeks for the transcripts to be prepared. You can pay extra money and get real-time transcripts, but they're close. It's sort of like watching closed captioning on TV. It's close, but it's not perfect. Everything's recorded. They go back after the reporters go back after the fact, clean up those transcripts and get them perfect based on the audio. So you could get some rough draft real-time reporting, but the reality is, in order to submit your motion for new trial, you have to have transcripts of the testimony or the sidebars or whatever it was to support it. So it probably took several weeks for those transcripts to be finalized and in a manner such that they would be deemed accurate enough to rely upon in making a record for the purposes of the motion. So not terribly surprising. It is part theatrical. That's part, being a lawyer is part being quick on your feet, part having a minor in theater. In the ability to turn the switch on and off when you need to. So there is a skill set to it, but it's probably a mix of theater, but also the reality is it probably took several weeks for those transcripts to be finalized and made available for the attorneys for the purposes of generating a record.
Very good to know. Okay, the next thing I want to pick your brain about has to do with the grand jury investigation into obstruction of justice by Scientology and David Miscavige. I want to ask you a few things about this along the lines of, how hard of a thing is obstruction of justice to prove? How serious of an offense is it? What does it take to rise to obstruction of justice? And I'll start by asking you with this specific here. We've heard that Lisa Marie Presley was asked by a Scientology official to approach Jane Doe 1, who she was close friends with, and convince her not to cooperate with the police in the investigation that Jane Doe 1 herself had initiated by going to the police in the first place. They were basically using Lisa Marie Presley to ask Jane Doe 1, just back off, just, remove yourself from this thing that you started, stop cooperating. And that she testified. Now, we don't know if this was just in a sworn affidavit to the prosecutors in the Danny Masterson case, or if she testified in front of the grand jury, but that she testified David Miscavige was the person she reported back to about the results of her attempt, although she seemed to not want to say that it was David Miscavige who initially told her to do this, but that it was David Miscavige she reported back to. Would something like that just on its own, in your opinion, rise to obstruction of justice?
Yeah, absolutely. So obstruction of justice is the doing or the attempt to interfere with a legal proceeding or an investigation. Generally speaking, if you do a quick Google, the Cornell Law Institute comes up with the knowledge of a government proceeding and then the acting with the intent to interfere with that proceeding. And notice the way they phrase it: government proceeding. Obstruction of justice could be you refused, you told somebody you can't go testify to Congress. It could be you can't go to the police. It could be I'm going to tell a lie to the police. It could be interfering with somebody to try and intimidate or manipulate or otherwise get a witness or a complainant to change their story or withdraw allegations. Anything that interferes with the legal process, whether that's Congress or a court or a police investigation or a grand jury investigation, trying to get to and manipulate the jury either directly or through the manipulation or acts of a third party acting on your behalf, whatever it is. It's very, very broad. It's not terribly difficult to prove. And while it is absolutely severe, and in most places obstruction of justice is a felony, there are some minor misdemeanor variants of it. But when it comes to things like if you're directly manipulating or attempting to manipulate a jury or a witness, those are generally the felony style. The misdemeanor would be, oh, I told the police I didn't know where the body was, and I did, and then I told them well after. Or I knew where the kidnapped victim was being held and acted like I didn't know, and then I told them, but ultimately the person was rescued alive. If the person is rescued after they are unalive, that would possibly rise to the level of a felony. Obstruction of justice and accessory after the fact, or conspiracy or something like that. So it's not terribly difficult to prove. The severity of it is sort of fact specific, but they're the most common penalty is a fine. Although if it rises to a high enough level, it could certainly be grounds for jail time. I don't know anybody's going to go to big prison, even if they catch a felony. They're not going to go necessarily to prison for that, but they're certainly going to do jail time, I think.
That's what I wondered. Like another example that comes to mind is Damian Perkins is someone who was one of the only, what you could say, like actual witnesses present at the time when Danny Masterson attacked Jane Doe 1. And he was approached by a known a Scientologist and known Scientology spy, Eric Geisler. A phone call was made to Damian Perkins, basically threatening him. Hey, you know what's going to happen if you do this. Does that rise to obstruction of justice? Like,
Yeah,
if you
absolutely.
cooperate, if you testify, if you cooperate.
Yeah, because it's the attempt, even though you went through with it. If you don't go through with it, it's obstruction. But the fact that they attempted to interfere with you and you had the moral compass and the wherewithal to withstand the threats, it's still obstruction. In some jurisdictions, they might call attempted obstruction, but by and large, it's still obstruction. It's not just the doing of the act, but also the attempting of the act as well. So the attempt alone is good enough in most jurisdictions to satisfy it.
Okay, so it is possible that even if, and I keep saying Scientology, like an organization cannot be found guilty of obstruction of justice, right? It's got to be individuals.
No, an organization can, if it shows a concentrated effort. For example, it failed and went bankrupt, but Lehman Brothers back in 2008, when they failed, and the FBI and the SEC and the whoever was coming to look at the building, they were shredding documents. Same thing with Enron. The execs at Enron went to prison back in 2000 or 2001 down in Houston. When the SEC and the government came in, they were shredding documents like one floor above where the government was coming to secure evidence. That's absolutely obstruction of justice. And the company itself was convicted of a felony, and Arthur Anderson, the independent auditor, was also the entity was convicted of a felony, although that felony charge was later overturned. Businesses can and have been convicted of obstruction of justice crimes. Absolutely. Entities can as well as individuals.
Okay. So you wouldn't be shocked, though. Let's say, Xenu willing, this grand jury investigation moves forward. Some convictions come down for obstruction. You would not be shocked if it was all settled with some fines?
No, when the court, when I say the court, I mean the judge. When the court determines and imposes sentence, one of the things they consider is the purpose of this sentence is to punish the wrongdoer. And if in the determination of the court, money will not adequately punish the wrongdoer, they can change what the sentence is. There's a judge, I forget where he is, Michigan maybe or somewhere, I forget, but he's famous for like, you did this bad thing, so instead of fining you $150, you have to go do 2 8-hour work days at the city dump handling garbage. Because if I have hundreds of thousands of dollars, or a $10,000 check, that's no big deal. That's how much I spent for dinner at the club last night with 4 people. Like, that's no big deal. But I'm going to give you where you have to go do this disgusting thing that you think is demeaning, because that is more uncomfortable and more miserable for you than writing a check. So judges can get creative. It sort of depends on the state statutes, but yeah, fines are certainly possible. Jail time. Now with entities like a business or an organization like the church, if it is found guilty of obstruction of justice, you can't sentence it. You can only fine it. That is the only legal remedy available for entities, businesses, corporations are convicted of crimes. The only legal remedy is fines. Although that would certainly give rise to the consideration of tax exempt status and these other things. Does it violate public policy to interfere with investigations and stuff? And anytime I get this question, I always refer folks to Mike Render's video. He's got several really good videos because of where he used to work in OSA. What, in his opinion, what it's going to take to get the tax exempt status waived. And he talks about the public policy argument quite a bit. So I tend to refer people there because he's got some good material on it.
That's great. The next thing I want to pick your brain about has to do with conflicts of interests of judges and the nature of the relationship between judges that all work in the same courthouse. So, judge number 2 in Leah Remini's lawsuit against Scientology had to recuse herself, Barbara Shepper, because her husband is one of Scientology's attorneys and is representing Scientology in a civil matter presently. So the case gets reassigned to another judge in the same building. Now, someone told me all these judges, they all eat lunch together. Is it is it like if I was on Leah's team, I'd be thinking to myself, there's no way to know that this new judge is not a close personal friend of the previous judge, and the livelihood, the income of Barbara Shepard's family in large part depends on Scientology's money. Would it be crazy for someone in this situation on Leah's team to request a change of venue, to request the case be moved to a different courthouse?
No, would it be uncommon? No. I mean, is it worth a shot? I mean, it's a balancing of the equities. Are the judges that we have in this brick and mortar more or less friendly than folks that we might get? Because as you identified in your video earlier, you hit it around the head. It is absolutely a lottery system. The computer randomly assigns it a new judge. In small counties, that's a problem. In big counties, you have 50, 60 judges to pick from, maybe 100 judges. So yeah, is it possible? That may be something they're considering. I can tell you, so several years ago, back in it was during COVID, so 2020, 2021-ish, something like that, a judge in Oklahoma County was on trial, not in a criminal trial, but was on trial before the Judicial Conduct Committee for malfeasance in office. So if convicted, the worst thing that happens is you're thrown off the bench. You're not a felon. You're not a criminal. You just lose your judgeship and they throw you out of office. It's similar to like an impeachment trial of a president or something, right? And so they brought in all of her. She was in the largest county in Oklahoma with around 20 or 25 other judges in the building, and then another 5 or 6 in an outlying county that was part of the same district. So there's, say, 30 of them. They would meet once a month for the judicial conference where they talk about changes in laws, changes in rules, COVID protocol, whatever. And then they might eat lunch together from time to time or celebrate the retirement of a longtime county employee. But they all sort of said, we don't talk about our cases to one another because we never know if one's going to get taken from us or we're going to get assigned a new one. I might go to a judge and hypothetically say, hey, listen, you've been on the bench 30 years. I've been on the bench a month and a half. And I'm having this attorney who's not following the rules. I have people their cell phones are ringing in my courtroom. What are ways that you found that are effective to handle this situation? But they never come up and say, hey, Joe Bob, the attorney's in there running his mouth again. I can't get him to shut up. That never happens. They all said that because they are arbitrators, third-party arbitrators, neutral arbitrators of fact, most judges, all the judges to my knowledge, to hold that oath sacred, and they just don't talk about their cases to other people.
Right. So I guess what well, in that case that you're talking about, what was the judge being brought up or being tried for?
Sure. So she failed to respect the due process provision. Somebody had a cell phone go off in court, and that is one of the cardinal sins in court. You can't have a cell phone go off. Can't wear a hat. Generally, don't dress like me. Now, if you're an off the street person, dress what you have. You coming from work or whatever, but attorney certainly. And there was a guy and every judge comes in and says, "Hey, before we start, turn your cell phone off." Attorneys can use it for calendaring, but you can't sit there and text or talk on the phone. Put your phones away. Somebody's phone went off, and she held him in direct criminal contempt, where he was immediately remanded into custody, taken to the Oklahoma County Jail, and held. And the due process clause says you get notice. Hey, I'm telling you, you're in direct criminal contempt. But then a right to be heard, which is tell me why I shouldn't sentence you to jail. Give me all the mitigating factors in your life that says I should. And she didn't do that. She just immediately had him put in handcuffs and drug away. She was confrontational with witnesses. She was confrontational with attorneys. She was confrontational with courthouse staff. She was also behind. She had come from the private practice of law, like a lot of attorneys do, and had gotten into arrearages with the taxing and revenue authorities in the state and at the state and federal level. But she had entered a payment plan, was working on mitigating and remediating the situation and fixing it. But still, judges are supposed to be above reproach. You can't be sideways with the IRS and then also sit the bench. Like, you generally can't do that. So it was a variety of things, and ultimately she was convicted and was excused from the bench. But she's still practicing law. She went back to the private practice of law. She's still representing clients. It didn't put her law license at risk, and theoretically, she wasn't banned for life. She could run again for judge, and if she got reelected, she'd take the bench again. She was just kicked off the bench in that circumstance. But all of her colleague judges, all of her judges that served in the courthouse with her, both in the civil and the criminal, the family, the guardianship, all the dockets, sort of all gave testimony. The chief judge, the presiding judge, her colleague judges, and they all gave their experience in dealing with her, as well as their experience in dealing with all judges over the last 20 or 30 years, however long some of these folks had been in the courthouse.
Interesting. So I guess, I mean, to me, it comes down to something as simple as this. If Judge A has a husband that is an attorney for Scientology, and Judge B is friends with Judge A, couldn't Judge B's knowledge that his friend Judge A's husband literally, puts food on the table because of this client Scientology? To me, that's a conflict, but I don't know how the professionals see it.
Yeah, so it maybe appears like a conflict, but the reality is it's incumbent upon Judge B. One, it's incumbent upon Judge A not to talk about the matter ever to anybody. Hey, my husband represents whoever. But also, it's incumbent upon Judge B. If Judge A tries to talk about it, please don't talk to me about that case. That case is on my docket. I'm not. We can talk about anything. We can talk about golf. We can talk about tennis. We can talk about NASCAR. But we're not going to talk about this case. And most judges are going to respect that. There's also administrative remedies and punitive remedies in place for judges who don't follow the rules. So if the judges know that they do know because they're trained, we shouldn't be talking about cases that are on a docket with other people, and then they talk about cases on their dockets with other people, they're subject to discipline for malfeasance as well. So they should all be very well aware of what's happening.
Right. Okay. And last thing I wanted to pick your brain about has to do with the status of service upon David Miscavige in Lee Remini's lawsuit against David Miscavige. We've seen this show over and over again recently of the plaintiff's team providing evidence to the court that they've exhausted all possible avenues to serve David Miscavige. Scientology comes along and says, Your Honor, no, they haven't. They haven't tried hard enough. They didn't look under those rocks over there. And then, it takes months for the court to rule that David Miscavige has been served. The question I wanted to ask you about this. Does the fact that this whole show has already played out a couple of times in the last 6 months, and the fact that anyone can go through the case history in those cases and see exactly how Scientology tries to avoid this and how eventually, they're just trying to make you jump through hoops. Does the fact that we've already seen this show a couple times in the last 6 months have any bearing on how quickly or easily this new judge will be to accept and rule Miscavige has been served? Let's not have this show one more time.
Yeah, I think so. I think it does. Maybe indirectly, but I think it does. It gives Leah's attorneys a bucket of evidence, a bucket of argument that there is a demonstrated history of avoidance of service. It is the policy of the various organizations and the policy of the Keebler King and his handlers, both, that at all costs service is to be avoided. And you cannot simply avoid being subjected to the legal system by hiding behind walls and windows. So the judge could say, yeah, you do need to jump through all these hoops and go through all these details. But in reality, hey, judge, you can deem him served now because we served him the same way that they also served him in this other matter. Does he work here? No, he doesn't. Cool. I throw it at the feet of the receptionist. I put it in the hands of so-and-so. They touched it or they jumped out of the way. There's this misconception you have to put it in their hands. No, you have to make it available to them with their knowledge. I tried to hand it to him. I said, you've been served, and he refused to take it. I threw it at his feet. He refused to pick it up. That's his business, not mine. I confronted somebody. I attempted to serve them, and they can't say, I didn't touch it. It's like tag. You didn't tag me. It's not how it works. So, Judge, we can go through all this stuff, or if you look at what you're calling in the building, under a similar set of facts, not similar facts of material, but similar set of service facts, they made him jump through the hoops, but they did ultimately determine service was valid. In this case, our process servers did the exact same thing. So, yeah, I think it absolutely will have a bearing on. And the judge also doesn't want this miscellaneous crap before them all the time. They want this stuff. They want motions for summary judgment and really complicated discovery disputes. They want the really sexy parts of the case. They don't want people arguing over whether Bubba, the Sea Org member, was properly served, substitute served for Keebler King and whoever else.
Right. I'm just imagining some really ambitious process server tying papers to a drone and dropping them on the hood of his car while he's driving or something.
Yeah, I mean, and that's all very valid. I mean, there's some case law out there about states that there's a state that I don't know if they still do for at least one specific case on one specific set of facts allowed service through Facebook. They sent a Facebook Messenger message and saw that it had been read, and then at some point the guy comes in to challenge service, but he tells the judge he was asked, hey, does anybody have access to your Facebook? No, I'm the only person with my password. I've never been hacked. I've never been married. I've never this. I've never that. Nobody knows my password. I'm the only person with access to it. And the judge says, well, somebody read it, and you've told me you're the only one who has access to it. Ergo, 1 + 1 = you read it, so you've been served.
Very interesting.
Now that is the exception, not the rule. Digital and virtual service is really hard now. It's hard to prove, and I'm not a huge fan of it. But in that case, the judge said you were able to convince me that this was the only person who could have received this information, so I'm going to deem service valid.
Wow. All right, let's tackle some of these super chats, and we'll wrap this up. Mitchell Crimmy. If we viewers who are non-Scientologists willingly watch SPTV, are we SPs or at least PTS? If not, what term would we be? PTS is the right term, Mitchell. You nailed it. You would be PTS. Now, if you refuse to handle a disconnect, then you would then cross over to being an SP for having a knowing connection to known suppressive persons or groups and refusing to disallow known suppressive persons and groups. Excellent question. Steven says, my favorite duo, good evening from the land of tea and crumpets. Well, top of the morning to you. That's whatever. John Sostovsky, will Leah's case shed some light on where Scientology is hiding all of their money? I don't think they're hiding it because they don't have to hide it. Like, they are a fully tax exempt religious organization under the eyes of the law. Scientology International Management has a statistic called Sea Org reserves. Like, it's one of the major statistics of international management. Now, that's a statistic. I'm sure Sea Org reserves is probably composed of, I don't know, 100 different accounts, but they're not having to hide the money because they don't need to hide it. They also have the International Association of Scientologists that has its own accounts. They have the Church of Spiritual Technology that has its own accounts. I've never heard Scientology accused of hiding the money, at least not since the corporate reorganization after the Church of Scientology of California was shut down, basically. Does that all sound right to you, Zach?
Yeah, absolutely. They're not hiding it. I mean, it's sitting in a bank account that theoretically, with a subpoena, the government could look and see the bank account balances. They're not hiding it.
Yep. All right, Lori LeBlanc. Fed sentencing guidelines require organizations to have an effective compliance program to prevent illegal activity. Oh, that's interesting. Penalties can include criminal charges on the leaders. Will this or could this come into play in the Church of Scientology? This is interesting. What do you think?
Not at the state court level. The state court does not have the jurisdiction to enforce federal law. I mean, they sort of can, but I've never known a state court to just intentionally jump into federal law. They tend to reserve that for the federal courts. Yeah, at some point, if this becomes multi-jurisdictional and you're able to get into federal court, then absolutely. But as far as it pertains to the Masterson civil suit, the Remini civil suit, the Sea Org suit, the trafficking suit in Florida that are all in state court, no.
Very good to know. Steve Britton, does the person need both?
I know what he's asking here.
Go ahead. Can you read this for me?
Yeah. Does the person need both the mens rea and the actus reus on their own part for obstruction to stick? So a crime, generally speaking, a crime requires two things. It requires the mens rea, which is the mental component, and the actus reus, which is the physical component. So, for example, if I have a seizure and during that seizure I strike someone, that is not criminal battery, because although I had the actus reus, I didn't have the mens rea. I did not have control over the thought process that resulted in the battery. Okay. So generally, yes, it will need both the mens rea and the actus reus, although the physical act in this case isn't going to be physical. It could be the instruction, you do the thing. It doesn't mean there has to be a physical confrontation. It just means there has to be both the mental willingness or the mental intent. The mens rea is the intent element, and then the actus reus is the doing element. So you had to intend to obstruct or intend to engage in activity that would constitute obstruction, and then attempt to or actually conduct that activity. The mens rea is the intent, and the actus reus is the attempt or the actual doing of. So yeah, you would need them both.
Excellent. RV at the beach, thank you for the super sticker. Barbara Mangano. How much would it cost me to go into the Tampa, Oregon, pretend that I want to become a Scientologist? Barbara, you could probably get in and out of there with only about $50 of damage, $100, $250 at the most. You know, if you want to buy a book, buy an extension course, the most basic introductory course you could do there probably wouldn't cost you more than $100. That's my estimate. And if you do, try to document it. That would be amazing. Dan Mosqueda. Hey, Aaron, do you have a puppet to demo how David Miscavige would accept service? Could it be used in court? Unfortunately, all my Miscavige puppets have been moved outside of arm's reach right now. Otherwise, I'd be happy to demonstrate that. But it's usually just him running away with someone throwing something at him, because there's no way no one has ever actually handed Miscavige actual papers. That's not how he's been served in any of these cases in the last 10 years. That's for sure. All right. Well, that was it. Thanks for letting me pick your brain about these issues. That was very helpful. And guys, check out the description down below. I have linked again to Zach Morgan's channel called Your Lawyer Friend Zach. Definitely jump over there and subscribe to him as well. Anything else, Zach?
I try really hard to avoid doing lives when Aaron's live. But tonight at 8:30 Central, which is 8:30 Central, 9:30 on the East, 5:30 on the West. I've got a Saturday night special, so come hang out with me. Ask me questions. And some of it can be, you can talk about the Leah Remini case. Talk about anything you want to. If I don't know something, I'll tell you I don't know, and then it gives me a reason to go look it up and learn something. So appreciate all you guys coming out today.
Awesome, guys. Thank you so much for watching. Thanks to everyone who watches until the very end, and we'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not,